My name is Nuraina Hayati binti Karya Anwar. My number matric is 071432. To start with, equitable remedy is known as if a person who has been wronged by someone else is entitled to endure compensation by the court. The injury party can receive money as compensation for their injuries. There are two types of remedies, which are specific performance and injunction remedies. A breach of contract occurs when a person fails to fulfill its obligation in accordance with the terms set out in the contract between the two parties, including failure to deliver goods or service on a timely basis or even failure to pay the amount owed. Moreover, nature of equitable remedy is diverse as first, acts in personam. Acts in personam comes from the Latin word, which means against a person. This case is brought against a specific person. That person must receive a summons and a complaint in order to give the court jurisdiction to decide the case. The failure to obey the order of the court may be punished by fine or imprisonment. Next, nature of equitable remedy is always discretionary. The common law remedy for breach of contract is an example of a remedy available at law. If the plaintiff prove that the defendant violated the term of the contract and the plaintiff suffered damage as a result, the court may be award damages. There are also legal mechanisms to ensure that the defendant honors the damages awarded, and these are available in any arbitration award. The court has no discretion whether to award damages or assist in recovery. Furthermore, specific remedies is used by the court when no other remedy, including equitable compensation, provides adequate compensation to the other party. If the remedy puts the injured party in the situation in which he will have been in the contract had been fully fulfilled, the judge will make use of this option. The common reason why court award specific performance is the uniqueness of the subject matter of the contract. Injunction is that the court orders a party to do or to abstain from doing a specific act. Court order that prohibits a party from doing something or binding an order to perform an action. The injunction may be temporary in effect until the judgment is entered, called preliminary judgment. The efficiency of preliminary judgment is until a specific date after the conclusion of the proceeding is revealed by the court. Court generally only grant preliminary injunction as at last resort when the plaintiff can demonstrate that if his right has been violated or soon will be violated. Monetary compensation does not constitute sufficient compensation. The dominant of injunction is to prevent any continuation of legal wrong to harm or to breach the contract from its rise.
My name is Amirul Nakib bin Amiruddin. My number matric is 069420. The first type of injunction is prohibitory, which under this injunction, a person prohibits to do continuance of a wrongful act. This is the most common type of injunction. Secondly is the mandatory injunction. It is defined as the compact performance of the requisite act and less granted compared with the prohibitory injunction. Section 53 of Specific Relief Act (SRA) mentioned that when necessary to compel performance of certain acts to prevent breach of obligation, court in its discretion grant mandatory injunction to prevent breach complaint of and compel performance of the required acts. The third injunction is known as interlocutory injunction. According to Section 51 Clause 1 of the SRA, this particular injunction will continue until specified time or further order of court. Usually, a temporary injunction is given after informing all parties, allowing the defendant a chance to defend themselves fully. However, in urgent situation, it might be granted without notifying the other party initially.
My name is Nur Shazwani binti Abdul Halim, 070068. In addition, perpetual injunction is where a permanent relief granted by the court after full hearing of both parties. It will then be issued at the end of the trial to permanently restraining further mismanagement and settle the dispute between the parties. Okay, the next section, which is section 52, provide guidelines of perpetual injunction, where it may be granted to prevent breach of an obligation existing in favor of the applicant, whether it is expressly or implied. So the court in its discretionary may choose not to grant the injunction. and they will consider the equities and circumstances of the cases before granting the injunction. So similar to perpetual injunction, interim injunction is also granted by discretionary of the court. The facts will be considered by the court before granting, such as the urgency of the matter or the potential harm that the plaintiff may suffer if it is not granted. So basically, it is a temporary injunction that is granted during the legal proceeding is still impending to prevent injury to the plaintiff's property. So the last injunction that court may grant is the quatimate injunction. It is sought as a preventive relief when there is potential apprehension of harm, even if it is not occurred yet at the time injunction is requested. And the plaintiffs must prove a very strong probability the damages will be suffered by his party. And it is in plaintiff's duty to convince the court the proof of imminent danger or substantial harm. As in the Redland Brakes Limited and Morris case has laid down the requirements that has to be satisfied, where there must be a strong case of probability, it is imminent danger, and apprehended damages will be very substantial.
I'm Amira Yasmin binti Muhammad Khairul Anwar, using number metric 070469. So I'm going to continue our presentation with the conclusion for equitable remedies. To conclude, equitable remedies are necessary for the efficient operation of the legal systems. There are three main classes of equitable remedies, which is specific performance, injunctions, and restitution. Principle of justice, conscience, and preventing improper prosperity serve as the foundation for equitable remedies. A more customized and complex approach to justice is made possible by the court's freedom to provide equitable remedies, which it applies based on the particular fact of each case. When there are damages which are not sufficient remedy, specific performance demands parties to carry out their obligation under the agreement. The goal of rehabilitation is to stop unfair losses and return unlawful profits. Also, there are disadvantages of equitable remedies, which is the requirement for continuing oversight from the judiciary, confusion, and considerable delays. To final our analysis, equitable remedies are helpful addition to common law remedies, allowing a way for reaching justice and equity during situations where traditional remedies might not be effective. That's all from us. Thank you.